a few minutes. The matter before the Commission today is whether or not to allow to stand Denmark's Department of Natural Resources Environmental Control's decision to issue a permit to Diamond State Generation Partners, LLC, also known as Bloom Energy, to site within the coastal zone. We'll argue, the witnesses will present testimony that the project is seriously flawed. The process has errors in the application. There are omissions, and Bloom, in their application, will provide testimony that indicates that Denmark made a flawed decision in arriving at their conclusion to issue a permit.
Appeals under the Coastal Zone Act to this board. It's been recognized in case law, and as a matter of fact, there's an opinion that I cited, the Kearney decision in our papers that basically says it's incumbent upon this board to consider standing, and it should be considered as a threshold issue. So in light of that, we certainly don't believe that Mr. Nichols has standing to pursue this appeal. Standing requires that there be an injury in fact that is concrete and particularized, and candidly, to state a belief that I don't think this is right, or I don't think it's the right policy, or I don't think it's the right thing, that doesn't provide standing to make an appeal. And the Public Service Commission ruled, and it was granted the express authority by the Delaware General Assembly to rule. I don't look at this hearing as a forum to reopen that debate and reopen that argument, and I'm concerned that it be a common stuff. No one's proposed a combined cycle facility in the coastal zone. There's a fuel cell project that's proposed in the coastal zone. It doesn't need to prove it's the best technology. It doesn't need to prove it's better than anything else. It needs to prove that it meets the requirements of the Act.
In any case, yeah, first of all, I was advised when I arrived that Bloom or Diamond State Generating had made a motion to dismiss for lack of standing. I would like to join on behalf of Denmark in that motion. I don't believe Mr. Nichols has established through the papers presented. In this case, the Secretary got it right when he decided to issue the permit. The Coastal Zone Act and the regulations require the Secretary to consider 6 environmental factors. The Secretary did that, and that's shown in the papers that Denmark has provided as exhibits. Now that the decision to grant or reject an application for a permit in the coastal zone is a matter of discretion with the Secretary. He's not required to do a cost-benefit analysis of any particular type. He's not required to give any weight to any greater weight to the 6 environmental factors, one of the 6 environmental factors